Today we will explore the copyright laws and determine the type of copyright, permissions, and licensing required to use specific content. You will learn to identify when and how to obtain permission to use images of people and locations. Intellectual property, IP, refers to creations of the mind, such as inventions, artistic works, literary works, designs, and symbols, that are protected by law to give their creators exclusive rights. This legal protection allows creators to control the use, distribution, and monetization of their creations. 4 types of intellectual property. 1. Copyrights. 2. Patents. 3. Trademarks. 4. Trade secrets. Copyright law protects original works of authorship fixed in a tangible medium of expression. This means that the work must be original. The work must be independently created by the author and not copied from someone else. Creative. It must display a minimal degree of creativity. Fixed in a tangible medium. The work must be captured in a tangible form such as being written down, recorded, or saved digitally. Copyright protection grants the author, or the copyright holder, exclusive rights to their work for the life of the creator plus 70 years. Literary works, musical works, dramatic works, choreography, photos, digital works, sculptures, audio-visual works, sound recordings, and architectural designs are all protected under copyright laws. Ideas, procedures, methods, systems, names, titles, phrases, slogans, facts, data, government work, public domain, fashion, choreography, and work not in a tangible form are not protected under copyright. Copyright protection and registration. Copyright protection is automatic from the moment the work is created and fixed in a tangible fixed form. Registration is not required for protection, but it is recommended for potential legal benefits, such as the ability to file a lawsuit for infringement in the U.S. A derivative work is a new creation that is based on or adapted from an existing copyrighted work, such as a translation, musical arrangement, or movie adaptation. It incorporates elements of the original work and adds new, original authorship. The example to the right is an Associated Press photograph and the Hope poster created of Obama for the 2008 presidential campaign. In copyright law, a work made for hire, also known as work for hire, is a creative work where the copyright ownership belongs to someone other than the creator, usually the employer or commissioning party. This means the person who actually created the work does not own the copyright. Fair use and fair dealing are both legal doctrines that allow the use of copyrighted material without permission in certain circumstances. However, they differ in how they are defined and applied. Fair use, U.S., open-ended, allows for a variety of uses such as criticism, comment, news reporting, teaching, scholarship, and research. 4-factor test. What is the purpose of the use, the nature of the copyrighted work, the amount of the portion used, and the effect of the use on the potential market for the original? Transformative use. Emphasizes whether the new use transforms the original work, giving it a new meaning or purpose. Fair dealing, UK, Canada, etc., narrowly defined. Fair dealing typically lists specific, permissible uses of copyrighted material, such as research, private study, criticism, review, news reporting, education, parody, and satire. Prescriptive. If a use isn't on the list of permitted fair dealing uses, it's not considered a fair dealing. Creative Commons, CC, is a non-profit organization that provides free, easy-to-use legal tools to creators of original work. Creators give the public permission to share and use their work legally under specific conditions, while still retaining copyright ownership. Commercial use versus non-commercial use of copyrighted material typically involves using it for profit-making activities, such as selling products, advertising, or creating content for commercial purposes. Generally, you need permission from the copyright holder to use their work commercially. Copyright attribution refers to providing proper credit to the creator of a copyrighted work when using it, adapting it, or quoting it so that the copyright holder receives credit for their work and that others understand the original source of the material. Attribution typically involves identifying the author, title, source, and license, if applicable, of the work. No derivatives, ND, condition means that you are not allowed to create or distribute modified versions of the licensed work. Identical copies only. You can only copy and distribute the work in its exact original form. Attribution still required. Provide proper attribution to the original creator. Share alike, SA, is a condition that means any adaptation or derivative work created from the original material must be distributed under the same, or a compatible, license as the original work. The public domain refers to creative works that are not protected by copyright, meaning they can be freely used, adapted, and distributed by anyone without needing permission. This status can arise when a copyright expires, author's life plus 70 years. If the copyright owner failed to comply with renewal rules, if the creator intentionally dedicates their work to the public domain. Patents, trademarks and trade secrets. In intellectual property law, a patent is a legal right granted by a government to an inventor or owner. It gives the patent holder the exclusive right to exclude others from making, using, offering for sale, or selling the patented invention in the specified country for a limited time. To be granted a patent, the invention must be novel, new original design, useful, practical purpose, non-obvious, unique and not already known. A trademark is a word, name, symbol, or design, or any combination, used to identify and distinguish the goods or services of one party from those of others. It acts as a brand name or identifier in the marketplace. Types of trademarks. Trademark, TM, used for goods. Service mark, SM, used for services. Registered trademark, registered, signifies that a trademark is officially registered with the United States Patent and Trademark Office, USPTO. A trade secret is confidential information that a company keeps secret to gain a competitive edge. It can include formulas, practices, designs, or other information that provides economic value due to its secrecy. Unlike patents, trade secrets don't require registration and can be protected indefinitely as long as they remain confidential. Two famous examples of trade secrets are: the Coca-Cola formula is a trade secret, carefully guarded to prevent competitors from replicating the unique taste of the beverage. KFC's original recipe of 11 herbs and spices is one of the most famous and closely guarded trade secrets in the world. How do copyright laws apply to people and locations? A model release is a document that grants a photographer or videographer permission to use images or footage of a person for commercial or other purposes. Individuals depicted in the photo have rights regarding the use of their likeness, particularly if used commercially or in a way that implies endorsement. A location release grants permission to film or photograph on a specific piece of private property. Property owners of homes, buildings, landmarks, etc., have rights regarding the use of their property's image, especially if used for commercial purposes. You'll need a property release from the owner if the property is recognizable and featured in the photo. Who is the copyright owner of the photograph? The photographer generally owns the copyright to the image itself. To use the photo, you need permission from the copyright owner, the photographer or whoever they transferred the copyright to. Copyright law summary. Copyright laws protect original works of authorship, such as books, music, and movies, granting creators exclusive rights to reproduce, adapt, distribute, perform, and display their work. Copyright protection is automatic upon creation and fixation of the work in a tangible medium. Copyright protects the specific expression of an idea, not the idea itself. Written permission must be given to use locations or people in photos or video. U.S. copyright laws usually protect the creator's work until 70 years after death, allowing the creator to pass on the copyright to heirs. Creative Commons (CC) is a nonprofit organization that provides free, easy-to-use legal tools to creators of original work to help them share their work with specific conditions. Patents protect inventions, trademarks protect company identifiers like a logo, and trade secrets protect a company's secret device or technique.